everyone. This is Shweta Devgan. Welcome to the thorough newspaper analysis for 20th January 2023. We have some very important legal topics to discuss today, specifically from the editorials of the Hindu and the Indian Express. The first editorial here being Judging a Decade of the POCSO Act from the Hindu. It has been 10 years since the Protection of Children from Sexual Offences, that is the POCSO Act, came into picture in 2012. While the poor rate of conviction under POCSO and the reduction of age of consent from 18 to 16, let us evaluate the impact this legislation has had. The biggest feature of the POCSO Act is that it is gender neutral. Chhattisgarh alone has had a 0.8% rate, that is 0.8 males for every 1,000 POCSO cases. Awareness has also greatly increased since non reporting of offences under the POCSO Act is also an offence. This makes hiding offences against children comparatively difficult. The storage of child pornography has been made a new offence, and offence of sexual assault has been defined properly with increased minimum punishment. Investigation, however, largely happens under the Code of Criminal Procedure, and following procedures are undertaken: recording the statement of the prosecutrix, medical and forensic examination, determination of the age of the child. However, despite the support extended by the center, the inclusion of women police in the force has been half hearted, with some police officers having no women staff at all. According to the case law Shafi Muhammad versus the state of Himachal Pradesh, which came in the year 2018, the scene of crime of heinous offences can be recorded and preserved. However, the pilot project in this regard is yet to be implemented by the states. The lack of pilot project also means that the video recording would lack integrity, and hence the evidence in itself becomes challenged. In addition to this, there are some other issues, like the forensic examination labs do not have proper equipment, and hence the examination becomes time consuming. The two finger test, despite being banned, is still prevalent. Determining the age of victim under POCSO is through the examination of the school registers by the investigating officers. In the case of Jarnail Singh versus State of Haryana, the Supreme Court held that there should be some legal provision which forms the basis for determination of age. However, POCSO as of yet has no such provision. This is important since once the medical examination scope makes a minor or a major, the acquittal grounds increase, like that of injury to private parts and consent. The time period of investigation is also not defined under POCSO, and hence CRPC takes precedence. According to the Code of Criminal Procedure, there has to be a charge sheet that is filed within 2 months. Thus, focus is on the time limit instead of the quality of the investigation. Once the charge sheet is filed, the accused too has a chance of getting a bail. Thus, the expedited timing only helps the accused and not the victim. For those of you who are preparing for judiciary examinations like UP, Gujarat, etc., you may know that POCSO Act is being tested in these state judiciaries. Apart from that, it does have a lot of relevance when it comes to essay writing examinations. With this, let's get on to the next editorial for the day, which is Open the Collegium Door. The debate on collegium is ongoing. The Constitution of India originally envisaged the induction of judges by President after considering the views of the Chief Justice of India. Instead, appointments are now made by a body that is solely headed by the judges and called the body, and this body is called the collegium. Hence, the present cries of asking government representation in the body as a response of charges of insularity and opacity in the decision making of the collegium. Previously, the recommendation of the 2015 NJAC committee was struck down by the Supreme Court, stating that the same harmed the independence of the judiciary. While talking of the basic structure doctrine, it is pertinent to remember that the Constitution is supreme and not the Parliament. The organs of the state must all function under the Constitution, and the laws must pass the constitutional test, which is the duty of the courts to administer. However, the practice of judges being appointed by judges will only further the rift between the judiciary and the executive. Instead of the collegium, a revised version of the NJAC committee could be looked into. There could be three judges in the committee, which would greatly decrease the fear of undermining judicial independence. Of the remaining two chairs, one could be given to the law minister, who voices the opinion of the government, while the other seat could be given to the bar. Giving a seat to the bar would serve as an excellent system for bringing more lawyers into the folds of the judges. The present system or the setup would also remove the objection that the NJAC committee has had no relation with the law at all. So, these are a couple of recommendations that this editorial cites so far as having the NJAC being reconstituted as a body is concerned. The next editorial briefly discusses about the National Education Policy. We are well aware of this National Education Policy 2020. For those of you who are preparing for the UGC NET examination, must know that this is often tested in your paper 1. This policy talks about the universalization of education from preschool to secondary level with a 100% gross enrollment ratio in school education by 2030. The gross enrollment ratio in higher education is to be raised by 50% by 2035. 3.5 crore seats are to be added in higher education. There has to be no rigid separation between academic streams, extracurricular vocational streams in school. NEP 2020 will also bring 2 crore out of school children back to the mainstream. Vocational education also has to start from 6 standards along with internships. In light of this fact, the editorial particularly talks about the annual status report of education that was published in 2022. This report shows that NEP 2020, that is your National Education Policy 2020, lays a lot of stress on foundational literacy and numeracy skills. To this end, the National Initiative for Proficiency in Reading with Understanding and Numeracy, the Nipun Bharat scheme, has gained significant traction in translating policy into action. Let me repeat the name of the scheme because it is very important for your multiple choice based question exams. The Nipun scheme talks about National Initiative for Proficiency in Reading with Understanding and Numeracy. With this, let's move on to the news updates. There has been an order issued for menstrual leaves in Kerala universities. The Higher Education Department of Kerala State has released an official order. The order allows menstrual leaves in all universities under the department. Students will now get 60 days of menstrual leaves. Women officers in command soon. The Army has begun the process for selection of women officers for command postings in the rank of colonel. Women Officers Special Number 3 Selection Board is being conducted for promotion from the rank of lieutenant colonel to colonel. This flows from the Supreme Court judgment in 2021 upholding an early judgment granting permanent commission as well as command postings to women officers in all arms and services other than combat. The PM has very recently inaugurated 2 new metro lines in Mumbai. He has also launched the PM Swanidhi Yojana in Mumbai. The next news talks about Army to get first Apache attack helicopter in February 24. The first fuselage of Indian Army's contract for 6 AH-64E Apache attack helicopters has rolled out of the Tata Boeing Aerospace Limited TBAL facility in Hyderabad. Let's remember the Tata Boeing Aerospace Limited, the TBAL facility is in Hyderabad. The first Apache is scheduled to be delivered to the Army in February 2024. Training of Army aviation pilots and technicians has already commenced in the US. This brings us to our next international news, which is about Jacinda Ardern to quit. Jacinda Ardern is quitting as New Zealand's Prime Minister ahead of this year's election. She said in a public statement that she no longer has enough tank to lead. New Zealand will choose its next Prime Minister in a general election on October 14th. Until then, Jacinda Ardern would continue to serve as electorate MP. The next news is very important if you are preparing for any of the banking exams. It tells us about LIC unveiling Jeevan Azad Limited Premium Plan. As per the policy documents, the minimum basic sum assured under LIC Jeevan Azad is rupees 2 lakh, while the maximum basic sum assured has been set at rupees 5 lakhs. It is a limited time period premium payment plan. The next news update is about an update from defense again. It talks about Vagir, Navy's fifth Scorpene class submarine to be commissioned on January 2023. Indian Navy is all set to commission the indigenously developed fifth Kalwari class submarine INS Vagir on January 23. The Scorpene submarine will be commissioned in the presence of the Chief of Naval Staff Admiral R. Hari Kumar as the chief guest. Coming on to the legal updates. In the case of Bimla Tiwari versus State of Bihar, it has been held that process of criminal law not for money recovery, bail can be granted irrespective of the payment of the money involved. This is a Supreme Court judgment where it was emphasized that the process of criminal law cannot be utilized for arm twisting and money recovery, particularly while opposing the prayer for bail, the Supreme Court observed in an order passed recently. The bench of Justice Dinesh Maheshwari and Rishikesh Roy observed that the recovery of money is essentially within the realm of civil proceedings. There is no justification in adopting such a course that for the purpose of being given the concession of pre-arrest bail, the person apprehending arrest ought to make the payment, the court said. In the next case of the Supreme Court, that is NN Global Mercantile Private Limited versus MS Indo Unique Flame Limited and others, the Supreme Court held whether arbitration agreement is duly stamped must be left for the arbitrator to decide. This was particularly highlighted by the Amicus Curiae to the Supreme Court. A constitution bench of the Supreme Court continued hearing submissions made by the Amicus Curiae senior advocate Mr. Gaurav Banerjee in a three-judge reference which raised the issue whether arbitration clause in contract which is required to be registered and stamped but is not registered and stamped is valid and enforceable. We all know that an Amicus Curiae is a friend of the court. So this brings us to the end of our thorough newspaper analysis today. I really hope that you enjoyed it as much as I did enjoyed delivering this thorough newspaper analysis to you. See you tomorrow. Thank you.